The language is clear. 3231. I mean, it's not qualified. So it seems like if we disagree with your reading of Schooner Exchange as a subject matter jurisdiction case, I mean, as we just said in the last case, the word jurisdiction is of many, many meanings. I mean, in many ways, it's kind of like a personal jurisdiction claim, and this goes back to what Justice Thomas was saying. I mean, it seems to me like maybe one reason we don't see these prosecutions is because the executive understands foreign countries to have absolute immunity, and so would rarely assert them, because I agree with Justice Thomas, we typically think of immunity as something that can be waived, and then 3231 is just simply saying that if there is a situation in which there is no immunity, in which the conditions are otherwise right, that the district court is available. But there are all kinds of reasons, maybe as a matter of substantive law, as a matter of the immunity defense, why that prosecution never gets brought. What's wrong with that?
Well, let me just take you back to the founding, because it's not just, Section 9 is a jurisdictional provision that has the Alien Tort Statute, and it has the 1331 predecessor plus the admiralty jurisdiction. In Section 13 of the same Judiciary Act, this court got original jurisdiction over diplomats and their servants. The first Congress made it a crime to prosecute a domestic servant or a diplomat, and it seems inconceivable that the first Congress thought that a district court had jurisdiction to convict a foreign country. And if I can just argue about instrumentalities, because I hear you about President Biden or President anyone on instrumentalities abroad, but we have over 90 corporations. We have Voice of America, Export-Import Bank, and one person's freedom fighter is another person's terrorist. Our U.S. instrumentalities do stuff abroad and could be seen to aid and abet terrorism.